Hello, everyone, and thank you for attending today's webinar, State and Federal Implementation of Industrial Hemp Laws. My name is Gayle Mercier. I'm the chair of the real estate group at Thompson Coburn, and I'm also the co-chair of our cannabis industry practice group. Just to give you a little bit of background, Thompson Coburn is a St. Louis-based law firm with over 380 lawyers nationwide, with offices in St. Louis, Chicago, Belleville, Washington, D.C., Los Angeles, and our recently opened office in Dallas, Texas. Our cannabis practice is committed to advancing the interests of the industry, and we've been working in the cannabis space now out of our LA and Chicago offices for a little more than 4 years, and more recently in Missouri with the passage of Amendment 2 in 2018. At Thompson Coburn, we leverage this experience to plan for and promote long-term success of our cannabis clients. As a full-service law firm, we assist the cannabis industry in a variety of areas, and we basically take a horizontal approach in that members of our cannabis industry practice group are made up from almost all of the other practice areas at the firm. And those areas include real estate, intellectual property, healthcare, corporate and securities, tax, licensing, labor and employment, regulatory compliance, business lit, private investment, and product liability, as well as a few others that I didn't mention. But those are the big ones. And with that, I have a few housekeeping items that I want to go through before we start. Before we begin, if you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We will try to answer these questions during the webcast, but if a fuller answer is needed, if we don't know the answer or if we run out of time, it will be answered later via email. A copy of today's slide deck is available in the resource widget as well, and we encourage you to download any resources or links that you may find useful. You can find additional answers to some common technical issues located in the Help widget at the bottom of your screen. This webinar is approved for 1.2 hours of general CLE credit in Missouri, 1 hour of general CLE credit in California and Illinois, and CLE credit in Texas is currently pending. We award CLE credit based on attendance for the entire 60 minutes. From time to time, you will be required to click a pop-up screen to reflect your continued engagement. We value your opinions and appreciate your participation in the course. And with that, I'm going to turn it over to Spencer Owens, who is also a member of the real estate practice group as well as our cannabis industry group. Spencer?
Thanks, Gayle. As Gayle mentioned, my name is Spencer Owens. I'm an attorney in the St. Louis office. I'm also a member of the real estate group along with Gayle, and I'm also a member of the cannabis practice group with Thompson Coburn. And I'd also like to begin by thanking everybody for tuning in to this webinar in these very unusual and uncertain times. We'd like to continue to offer these webinars during these weird times in order to keep everybody current on different trends and topics in the law. So thanks again for tuning in, and I'm going to run through everything that we are going to cover in this webinar. So we're going to first begin with discussing the definitions of hemp and marijuana under state and federal law. I'll give an overview of the 2018 Farm Bill. We'll discuss the status of state and federal implementation of the 2018 Farm Bill. We'll analyze select portions of USDA regulations regarding inspection, testing, and penalties. We'll look at variations among states regarding cultivation and processing hemp. And then we'll conclude with a discussion of complications regarding interstate transportation of hemp and its derivatives. So by way of introduction, hemp is actually widely to believe the next frontier for American agriculture. And, I say the next frontier, but that's not entirely true because hemp has actually been part of American agriculture for a very long time. It only was relatively recently outlawed along with marijuana back in the early 20th century. And then again, with the passage of the Controlled Substances Act in 1970, it was scheduled as a Schedule I drug along with marijuana and was prohibited. That said, we'll discuss how it has become federally legal and the next steps for the American hemp agriculture industry. Currently, China is the world's largest producer and exporter of industrial hemp, but if the American experiment with the hemp industry is a success, we can likely see China being replaced as number one with American exports. Cultivators in the hemp industry can project significant profits if successful in the hemp industry, roughly on average $250 to $300 per acre after cost. So they're netting that out. And you can compare that to soybean crops, which at their peak in 2012 netted out roughly $120 per acre for large-scale cultivators. So, you see roughly doubling the profit if is a big qualifier, if all of the relative compliance hurdles and other costs are considered and met by the cultivator. So let's jump right in with discussing the definitions of hemp under state and federal law, and specifically, what are the risks of hemp falling outside of the state and federal definitions of hemp? And the short answer to that question is that the risk to a cultivator is the absolute forfeiture and disposal of their crop, which would result in a total loss for that cultivator and might subject the cultivator to possible criminal penalties under state and federal law. I believe that the definitions that we are about to examine are extremely, extremely important and drive the policy under the 2018 Farm Bill. So we'll begin by examining the definition of marijuana under the Controlled Substances Act, which, as I mentioned before, was passed in 1970, became effective in 1971, and has driven the drug policy in the United States ever since. It predates, obviously, because it was passed in 1970 and became effective in 71, it predates both of the Farm Bills, the 2014 and the 2018 Farm Bill. And here we see the what I'll call the pre-2018 Farm Bill definition of marijuana that includes all parts of the plant cannabis sativa L, whether growing or not, the seeds, the resin, and every compound manufacturer and other items, a laundry list of items included in that definition. Around the middle of the paragraph, you see that there's a slight carve-out for mature stalks of the plant, fiber produced therefrom, as well as oil, cake, and seeds produced therefrom that are incapable of germination. Now, just looking at that small carve-out in the middle of the paragraph, it almost sounds like, hemp might be able to, what we today consider to be hemp might fall within that definition. However, the DEA and the DOJ almost never took that position prior to the 2018 Farm Bill passage. Instead, they, as I mentioned before, lumped hemp along in with marijuana and treated it as a federally illegal substance. Now let's contrast this definition with the definition as revised by the 2018 Farm Bill. As you can see, paragraph 16 was split into two subparagraphs, A and B. And subparagraph A is the first part of the old definition. As you see, all parts of the plant, cannabis sativa L, whether growing or not, the seeds, and blah, blah, blah. And you also see a new subparagraph B, which itself is split into two subparagraphs, Roman 1 and Roman 2. And Roman 2 is that strange mature stock carve-out that we examined on the last slide. What is of interest to us is Roman 1, which is hemp as defined in section 1693O of Title VII, which was added by the Farm Bill. That is our operative 2018 Farm Bill language. So looking at this definition, we know that whatever hemp is, it's not marijuana, and therefore it's not subject to the Controlled Substances Act. So what exactly is hemp? Well, here's the definition for what hemp is under the 2018 Farm Bill, and this is exactly what is carved out of the definition of marijuana. And it's interesting because in the first sentence of this definition, you see almost the same definition for what we saw was marijuana, the plant cannabis sativa L and any part thereof. However, there's a huge caveat at the end of the sentence, which begins with a delta-9 tetrahydrocannabinol concentration of not more than 0.3% on a dry weight basis. And that sentence, or that clause in this definition is, in my opinion, the most important set of words in the entire 2018 Farm Bill. It's the crux of the bill because it sets the stage for all of the inspection, sampling, and testing policies that the United States Department of Agriculture and the states are required to enforce, and it's a qualitative distinguisher between what Congress defines as hemp and illegal marijuana. Everything centers on this tetrahydrocannabinol concentration percentage. And just by way of background for those who are not familiar with these chemical terms, delta-9 tetrahydrocannabinol is also known as THC, colloquially, and it is the main psychoactive component of marijuana, and it is the substance that the Controlled Substance Act and the DEA and the Department of Justice are most interested in regulating with their various and sundry policies. So we know by looking at these definitions that anything that is cannabis, of the genus cannabis, that isn't hemp is marijuana based on our definition. And anything that is marijuana is federally illegal. And this distinction is important because it can set somebody up it can set a cultivator up for forfeiture and their harvest to destruction by the DEA and the USDA. Moreover, to the extent that a harvest is destroyed because it was non-compliant with the definition of hemp, any crop insurance that was in effect with respect to that harvest would not cover the loss. So the cultivator would be out the value of that crop, the cost of planting the crop, and possibly subject to criminal penalties. And as I mentioned before, these definitions form a major basis of the regulatory policy created by the 2018 Farm Bills and, as we'll discuss later, state hemp cultivation programs. So if you can imagine a cultivator who produces 100% compliant hemp, so they followed the law to the letter, that cultivator would be, based on these definitions and based on the law, operating a 100% federally legal business and would be entitled to be treated accordingly for tax, insurance, and other purposes. But as we will examine later, that's not an easy task. Cultivating 100% compliant hemp every single time is not easy. So now we'll discuss what the current state of the law is and what the current state of the law has been for the past couple of years with respect to limited hemp production under various state programs. Yeah.
Hey Spencer, can I pop in here and ask a real quick question, just a clarification?
Sure.
Would it be possible to have products that are both hemp and not marijuana if they're both derived from a mature stalk?
Yes, actually, you're absolutely correct. That carve out that we examined earlier, what I'll call the stock carve out, mature stock carve out, I guess you could have a situation where you have products derived from the mature stalks of a cannabis plant that exceed they're not hemp because they exceed the THC content mentioned in the definition of hemp, but they're not marijuana because of that mature stock definition.
Gotcha,
so it is entirely possible to have hemp and what I'll just call not marijuana.
Thank you.
Yep, no problem. So let's talk about the way hemp production has been handled the past couple of years. And that has been under the 2014 Farm Bill, which allowed the USDA and state departments of agriculture to create pilot programs to license hemp cultivators for market research and scientific research purposes. Mostly, we saw a lot of universities engage in this program. Most notably, we saw the University of Kentucky make a lot of use of Kentucky's 2014 Farm Bill program, and it is widely believed that the wide utilization by the University of Kentucky was part of the impetus for Senator Mitch McConnell moving the 2018 Farm Bill through the U.S. Senate when it came up earlier in late 2017 and early 2018. It is important to note that any authorizations that the states have under the 2014 Farm Bill end on October 31st, 2020. There's currently a push by many of the states who have 2014 Farm Bill authorizations to actually extend the sunset date for the 2014 Farm Bill authorizations to December 31st, 2014, to allow the hemp cultivators in those states to begin and end their authorizations on the calendar year rather than just what we consider almost an arbitrary cutoff date of October 31st. And I'm sure many of you have seen CBD products and hemp products flooding the market even before passage of the 2018 Farm Bill. And you might have wondered, why are these on the market? I thought hemp was, lumped in with marijuana. And you saw those products hit the market due to authorizations under the 2014 Farm Bill. And all but 2 states have actually availed themselves of the 2014 Farm Bill. I know Idaho and I believe Mississippi were the 2 that did not. Now let's talk about the 2018 Farm Bill. And at its most basic level, it sets up a federal regulatory regime that is administered by the USDA. And state and tribal governments, and I'll put a quick note for tribal governments. Tribal governments are treated in the exact same manner, for the most part, as states under the 2018 Farm Bill. They are given the authority to authorize and license hemp cultivators if the states and tribal governments submit a regulatory plan to the USDA for approval. Now, the USDA will review these plans for minimum regulatory requirements that the 2018 Farm Bill set forth in the text of the statute and in the regulations adopted by the USDA in October. And we'll shortly get into the actual requirements, some of the requirements in these state plans. The states are also free to not adopt a plan, and they can actually do one of 2 things if they don't adopt a plan. They can have their hemp cultivation program administered directly by the USDA, which means that the State Department of Agriculture would have no involvement or very little involvement with the actual licensing of the hemp cultivators. Or the state can actually they cannot adopt a plan and prohibit the production of hemp within their borders. And it's important to note that it's the production only, and we'll get into why that is, but states are given the freedom to prohibit the production and cultivation of hemp within their borders. So onto the requirements, the minimum requirements of the state and tribal plans under the 2018 Farm Bill. Essentially, the states have to implement a complete biographical information gathering system for applicants for hemp cultivation licenses. The USDA is interested in knowing everything that they can about these applicants, just in case one is awarded a license and the USDA needs to enforce federal laws or any other policies that they may have against the applicants. And this includes a complete legal description of the property or properties used for cultivation. It also includes site inspection and sample testing procedures. We'll get into a little bit of the nitty-gritty on these procedures. And it also includes effective, quote-unquote, effective disposal procedures for when a hemp harvest exceeds the maximum THC concentration provided by law, which is at 0.3% on a dry weight basis. It also sets forth penalties for negligent and willful violations of the Farm Bill and under state laws. And it requires that the state and tribal governments certify that they have enough staff and resources to implement and ensure compliance with the plan that was submitted to the USDA. And the USDA's interest in this, in having the state certified to that effect, is that they don't want states submitting, promising the farm in, so to speak, in these plans, and then failing to live up to their end and non-compliant hemp being released into the market in violation of the Controlled Substances Act.
Spencer, can I interject there as well and ask a question? That seems like an odd inclusion. Do you have any information or background? I mean, have there been these programs put into place without enough staff? I know on the cannabis site in Missouri that we've seen some of that, but I was just wondering if there was some precedent for that.
I'm not entirely familiar with any precedent that the USDA might have been pointing to when they included this program. I suppose they may have just been concerned, as I said, that a state or a tribal government was just going to underfund their program intentionally in order to give their farmers a quote-unquote regulatory break. That's my theory, my working theory as to why this was included. But
right.
I might be able to beat a couple bushes and see what I can find out with respect to the USDA's thinking on this issue.
Yeah, no, that's just interesting. I mean, it makes sense, but I just was wondering if there had been some case to point to that maybe there was not enough staff, or if they were just concerned about being able to regulate it adequately. Thank you.
Right. Yep, no problem. So let's discuss where we are in the process of implementing the 2018 Farm Bill. So currently, as I alluded to earlier, the USDA released its regulations, its final interim rule, in October of last year. And it set forth those minimum requirements that we just ran through, and it set forth specific procedures for inspection, sampling, and testing, and we'll get into those. It's important to note that the USDA accepted comments from the time that the interim rule was released in October 2019 up until the end of January of this year. And the USDA it is possible that the USDA may revise the final interim rule based on the comments that they received during that comment period. I haven't seen anything indicating that the USDA will for sure change things. However, they have clarified a number of their positions since then in late February that we will discuss in a little bit. As I mentioned earlier, the authorizations under the 2014 Farm Bill expire in late October, and there are some states who are operating their hemp pilot programs based solely on that 2014 Farm Bill authorization. There's a natural incentive for states to actually submit a permanent or essentially a 2018 Farm Bill plan to the USDA for review and approval before those authorizations expire in October of this year. Because if they don't and those authorizations expire without a replacement, it's likely that the hemp cultivators in those states will be considered to be cultivating marijuana because it's not approved. They will be cultivating an unapproved hemp marijuana product, and they would be subject to penalties under the Controlled Substances Act. Now, on the state level, here's a map of the current status. I think I updated this earlier this week. This is the current status as to which states have submitted USDA plans and who has not. The states in green are the states who currently have an approved plan in place. The yellow states are states who are within the process in some shape or form. They have they're either drafting their plan, they've submitted their plan and it's under review by the USDA, or they're still in the planning stages. The purple states are the states, as I mentioned before, that are currently operating solely under a 2014 Farm Bill authorization. Those are the states who will be kind of under the gun, so to speak, for the next couple of months until the end of October. The single blue state is the one state who, as I mentioned before, didn't submit a plan but chose instead to have the USDA administer their hemp cultivation program. And finally, the two states in red, Idaho and Mississippi, are the two states where hemp production is currently illegal under state law. Mississippi never submitted a 2014 Farm Bill plan or authorization. They never got authorization under the 2014 Farm Bill, and we shall see if there will be a plan submitted by Mississippi later. Idaho has indicated that it has no plans whatsoever to submit a USDA plan, and they continue to, as we will discuss later, treat hemp in a very hostile manner under state law. So I mentioned the specifics of the USDA's interim final rule earlier. So let's talk about the requirements under the interim final rule. And the final rule, or the interim final rule, can be found at 7 Code of Federal Regulations, Part 990. And the first requirement that we're going to look at is with respect to sampling and testing. So under the USDA's interim final rule, as it was written, cultivators are required to provide a sample to a DEA-certified laboratory within 15 days of harvest for testing. And functionally, that means that they have to test the hemp harvest must be sampled before it is harvested and sent to the DEA lab within 15 days of it being harvested. And this requirement caused a lot of controversy amongst hemp cultivators because there simply are not that many DEA-certified labs. It's a rigorous process for a laboratory to become DEA-certified. And so a lot of cultivators were concerned that this is going to cause a lot of bottlenecks and inefficiencies in the process and may lead to spoilage on the fields as they're waiting for their hemp harvests to be tested. However, as I alluded to earlier, at the end of February, the USDA and the DEA announced that they're delaying enforcement of this requirement. However, it's important to note that many state plans adopted this DEA-certified laboratory requirement, meaning they still require that harvest be tested by a DEA-certified laboratory. So just because the federal government has announce that they're delaying enforcement does not mean that the states will follow suit. We need for a cultivator, it pays to double check with the state regulators as to whether they're going to delay enforcement of that requirement under their plans. A second question, or the second provision that we're going to talk about is what's called the total THC requirement. On the left here, we see the text of a selection with respect to the total THC requirement. And it essentially, let's read it. It says, in the context of this part, post-decarboxylation means testing methodologies for THC concentration levels in hemp, where the total potential THC content is derived from the sum of the THC and THCA content is then determined and reported on a dry weight basis. THCA is delta-9 tetrahydrocannabinol acid. And I'm going to go out of order really quickly here. I explained this a little bit later, but it is an unactivated form of THC, and it has the potential to become the psychoactive substance THC under certain circumstances. On the right here, we have that same definition that we examined earlier with respect to hemp, included in the 2018 Farm Bill. And as you can see, the Farm Bill did not make a distinction between the total potential concentration, nor did it have any mention of the THCA content. Now, the USDA has taken the position that the language of the statute, delta-9 tetrahydrocannabinol concentration, implies that it's the total percentage of THC, which includes what could become THC, meaning the THCA. Now, why is this important? Well, the rule, as we kind of discussed before, and it's reprinted in the rule, hemp harvests are required to be at or under 0.3% total THC on a dry weight basis within 15 days of their harvest. And recall that definition that we examined earlier, that very important clause at the very end. And the implications of exceeding that threshold is that the harvest will be considered to be marijuana and will be destroyed. It's important to note here that the Farm Bill requires, quote unquote, effective disposal. However, the interim final rule released by the USDA reflects, it actually says that the crop must be destroyed, quote unquote, destroyed. That caused another controversy amongst cultivators because, it's wasteful to just destroy what could be a significant amount of plant material that could have other uses that aren't, commercial in nature. So in late February of this year, the USDA relaxed that requirement, and now cultivators are allowed to plow under or compost non-compliant crops as long as certain other, non-diversionary measures are met. Additionally, functionally, when the hemp is tested, it is assigned by a laboratory. It is assigned a THC percentage. At the same time, the laboratory calculates what's called a measurement of uncertainty, which is essentially a confidence level calculation that is a plus or minus number, and that gets added and subtracted to the THC concentration percentage to produce a range. Under the interim final rule, as long as one end of that range is at or below 0.3% THC, the harvest is determined to be compliant. So, for example, if we have a harvest that was assigned a total THC concentration of 0.35% or 0.05% over the 0.3% threshold, you have a range, and the laboratory calculated the measurement of uncertainty to be 0.06, you get a range of 0.29% and 0.41%. This harvest would be determined to be compliant under the interim final rule because the lower end of the range is under 0.3% THC.
And Spencer, I'm sorry, I have another question. That's pre-harvest, though, right?
That's correct.
So what happens if? Go ahead.
Well, I was going to say the USDA is really only concerned with hemp before it is harvested, because it's extremely. I mean, it's difficult to control THC levels before it's already hard enough to control THC levels before it's harvested, but it's next to impossible to control it afterwards. Really, that's why the USDA really only cares about before it's harvested.
So we really don't know what happens if it's under 0.3% when it's prior to the harvest, but then it turns hot during or after the extraction process. Is there any way? There's nothing regulating that?
It depends if the state will test. I assume the question is that your question means that after the hemp has been processed into a derivative product, and that would depend on whether the state or the USDA tests the derivative product again after after it's been processed. And that depends on the requirements of the individual state.
And that's a state-by-state basis. That's a state-by-state decision.
It presumably could be. Now, I haven't seen that anywhere yet, but that doesn't mean a state couldn't get their plan approved by the USDA with that requirement in place.
Gotcha. Thank you.
Yep, no problem. Now, this total THC requirement, as I alluded to when I was answering the question, is, again, it's pretty controversial because, as I mentioned before, when I went out of order, the THC is the prime psychoactive component, and THCA is the unactivated form of THC. And the THC levels, both THCA and delta-9 THC, can vary greatly based on a lot of factors that aren't necessarily within a cultivator's control. Now, the cultivator can control, to some degree, the amount of stress that their plants undergo, the seeds that they use. However, there are some things like the temperature at the time that the hemp is harvested or before or when it's tested, that the cultivator has no control over that, and those can actually bear on the amount of THC within the harvest. And so mitigating that total potential THC percentage is difficult and problematic, and it can be expensive. So it's something that, but because the stakes are so high with respect to producing compliant hemp, as we've discussed, it's incumbent on the cultivator to be as diligent as possible in keeping their hemp at or under that 0.3% threshold. And that's because there are certain penalties that are associated with producing non-compliant hemp, aside from having your crops seized and destroyed or composted and plowed under, So under the interim final rule and the Farm Bill, there's a threshold, 0.5% total THC, at which a cultivator is determined to be negligent. Now, that means that cultivators have a very small window between 0.3% and 0.5% in order to be considered negligent. Now, this negligent standard requires that the cultivator use quote unquote reasonable efforts to grow compliant hemp. And that's kind of what I alluded to earlier, using the correct seed, or using seeds that have a low THC percentage to begin with, taking all those steps to prevent plant stress and things like that. Those cultivators who do that will be considered to have committed a negligent violation of the Farm Bill, and they're required to work out a 2-year corrective action plan with their state. And the state can impose additional penalties for growing non-compliant hemp. And we'll talk about one state in particular, but it can be very severe for serial offenders. In fact, if a cultivator accrues 3 negligent violations within a 5-year period, the cultivator can have their license to produce hemp suspended for up to 5 years from the date of the 3rd violation, which can, that's a significant penalty that takes the cultivator out of the market, and it may even render that that cultivator ineligible to receive a license in other states where they may be seeking a licensure to cultivate hemp. So I keep saying this, but it's extremely important for cultivators to be extremely diligent in mitigating the total THC in their products. Additionally, if a state regulator finds that a cultivator had a culpable state greater than negligence, so meaning they acted willfully or intentionally in violating the total THC requirement, they can actually refer that violation to the state attorney general and the Department of Justice for prosecution under the Controlled Substances Act. So really this regulatory framework is designed to prevent cultivators from growing marijuana under the guise of producing hemp.
Spencer, are there also fines that are implemented in connection with that, or is it just, or does it really depend state by state what they work out with the state if it's on a negligent basis?
It depends on I think last I saw, states are free to determine the level of fine. What I've seen a lot of is states requiring the costs of, they require you to pay the cost of the test anyway, but they'll also require you to, cover their overhead for, enforcing the action enforcing against you, things like that. But yes, states can impose additional fines on cultivators who produce non-compliant hemp, and that can be part of that 2-year corrective action plan.
Gotcha. Thank you.
Yeah, no problem. So let's discuss briefly some variations amongst the states with respect to their hemp programs. And we see a variety of approaches under state law with respect to defining hemp and in the actual plans submitted themselves. Some states like Nebraska and Missouri carved out what we call hemp extracts and extracted resins from the definition of marijuana under their controlled substances laws. And what that does is it really facilitates the processing of industrial hemp into CBD extracts, and it facilitates bringing those products to the market. Other states, like Washington, expressly prohibit processing industrial hemp for an end human or human consumption at the very end. And it's interesting because the FDA has also taken this position of late over the past couple of years. Once the CBD products have been hitting the market, there is only one CBD product, Epidiolex, that has received FDA approval to be marketed under the Food, Drug, and Cosmetic Act. And so I won't get into the FDA's regulatory authority here, but it's just something to note that the FDA currently considers CBD products and other hemp products to be unfit for human consumption. But we've seen a major theme amongst the states, and it's I discussed the 0.5% cap for what we consider to be negligent violations. After that 0.5% cap, or I guess I'll call it a floor for purposes here, it's up to the state as to what level of THC will trigger those enhanced criminal penalties, such as notifying the state attorney general, the DEA, and the Department of Justice. And I've seen thus far in Iowa as high as 2% THC on a dry weight basis that would trigger notification of the federal government. And I mean, 2% is the difference between 0.5% and 2% is pretty significant. You'd have to, be it's hard to do, or it depends on how you see it. But if you're doing it intentionally, it's not that hard. So let's actually compare two states that have who have USDA approved plans. In fact, Iowa was, by my count, the latest state to have their plan approved by the USDA, and Montana, two states that I think have pretty strong agricultural industries within their respective states. So I kind of approached this from the perspective of a cultivator who would be interested in kind of the more logistical aspects of the state plan, because as I mentioned before, the substantive requirements under the interim final rule are the minimum requirements for these USDA plans. So the actual substance, the testing and inspection and the sampling requirements don't vary all that much from state to state. It's in these logistical elements and in the minutia where the states begin to differ greatly. And so beginning with the fees, you can see Montana charges $450 for the license, whereas Iowa charges no less than $500 plus $5 per acre. And it actually steps up in Iowa based on how much land is used for cultivation. So between 1 and 5 acres is $500 plus the $5 per acre. It steps up to $1,000 once you hit 5.1 acres to 10 acres, and then 10 and above, you hit $1,500 for the license plus the $5 per acre. Additionally, in Montana, you have a $400 planting fee just for the privilege of planting your crops, and you incur a $250 fee every time that you submit your samples for testing. Compare that to Iowa, where it's 4 times as the testing fee is 4 times as large at $1,000. Logistics-wise, in the application process, Iowa has a different application window for outdoor and indoor growers. Indoor growers can apply for their license at any time within the year, whereas outdoor growers have a date certain by which their application is required. So if I'm a cultivator and I miss that date and I have an outdoor operation, I just missed out on the entire growing season until the next time that the application window opens again. So that can be a huge deal, and it's just in the minutia of these state plans. By contrast, Montana has no distinction between outdoor and indoor growers, and they treat them in the exact same way. Compliance-wise, cultivators who grow non-compliant hemp in Montana, even just once, can be subject to additional regulatory scrutiny. And what do I mean by that? I mean, essentially the description of the program, of the plan of the Montana plan is that they would be subject to additional testing. So the samples may be tested more than once to make sure that they're staying compliant. And as I mentioned before, that can, every time that the samples are tested, that's another $250 that you're paying, or that the cultivator is paying to the state of Montana. So those can add up extremely quickly. In Iowa, one quirk of their compliance program is that only laboratories administered by the Iowa Department of Agriculture are permitted to test pre-harvest samples. And so that's something that's extremely important to know as a cultivator, and that's, where do you actually send your samples for testing? Okay, so now let's move on to a discussion of interstate transportation of hemp under the 2018 Farm Bill. And I've got a preliminary note here, and that's that states and tribes are not preempted from prohibiting the production of hemp within their border. And we discussed this above when we talked about what states can and cannot do. They can, and Idaho and Mississippi will likely do this, they will likely prohibit the production of hemp within their border. However, under Section 10.114 of the 2018 Farm Bill, and that's reproduced right here, states and tribal governments shall not prohibit the transportation or shipment of hemp or hemp products produced in accordance with Subtitle G of the Agricultural Marketing Act. And Subtitle G is the section with respect to the state plans. So this is important, that in accordance with sentence is extremely important because it requires for this interstate transportation regulation prohibition to apply, it requires that the hemp be produced in accordance with the 2018 Farm Bill. And so that has produced two positions that states can really take with respect to interstate transportation, and that's a permissive stance and a hostile stance. Both the 2014 and 2018 Farm Bills prohibited the states from restricting interstate transportation of industrial hemp cultivated in accordance with the laws. And this is the position that the USDA has taken in cases that have come up thus far under that section of the 2018 Farm Bill. But we've also seen an outright hostility towards interstate transportation, most notably in Idaho. And I've produced here kind of a small snippet of the Big Sky scientific case that came down in 2018 and 2019. And essentially in that case, a 13,000-pound hemp shipment was being transported from Oregon to Colorado by Big Sky Scientific, and that shipment was intercepted and seized by the Idaho State Police. Big Sky wanted to get its hemp shipment back because it's 13,000 pounds of hemp, and that's a significant amount of plant product. So they filed for a preliminary injunction against the Idaho State Police and the Ada County prosecutor. And they alleged that the hemp is hemp as defined under the 2018 Farm Bill. It's not a controlled substance, and under Section 10.114, which we just looked at, of the 2018 Farm Bill, Idaho is prohibited from interfering with the interstate transportation of hemp. Well, Big Sky lost this case because at the time, the USDA had not promulgated its interim final rule, and no state plans had been submitted for USDA approval. Recall that the Section 10.114 requires that the hemp be produced in accordance with the Agricultural Marketing Act as revised by the 2018 Farm Bill. It was impossible for Big Sky Scientific to have produced hemp under the 2018 Farm Bill, and therefore Idaho was permitted to interfere with that hemp shipment. I'm going to skip over the Mallory case because it's more of just an interesting outlier in federal enforcement, and I will address the elephant in the room before we go to questions, which is the effects of COVID-19 on the hemp industry. And so on the licensing side, we've seen many state departments of agriculture, and Missouri is included in that, pressing ahead with certification and licensure for hemp producers. And in these states that are still processing these applications, cultivators should expect higher than normal waiting periods, which is expected due to this emergency. as well as potential moratoriums on on-site inspections that may be required as part of those licensing processes. And those moratoriums could hold up the process for those applications. So the key for those cultivators is to communicate with their regulator and probably their attorneys to determine what steps can and should be taken with respect to their applications. On the operational side, the federal government, the Department of Homeland Security has determined that agriculture is an essential infrastructure, and hemp cultivation obviously falls within that definition. However, states, counties, and even individual municipalities have varied as to what they consider to be essential businesses. We've seen some states consider CBD retailers, medical and recreational cannabis dispensaries to be essential, and others don't. So again, it pays for a cultivator to pay close attention to their markets and to governmental orders at the state, county, and municipal level, and that those orders can change on extremely short notice, as we've seen in the past couple of weeks. And finally, agriculture is a pretty volatile industry, even in the best of times. And, we've heard a lot in the past couple of weeks about financial assistance for small businesses who are suffering as a result of COVID-19. So what's available for hemp cultivators? It's kind of an open question as to whether the hemp industry is eligible for aid under Small Business Administration programs added by the CARES Act. And in addition to those economic injury disaster loans, the forms for those loans actually specifically exclude agriculture and farms from the eligible applicants, though the act itself does not. So there's many people in the industry are pressing the federal government for a little bit of clarification on that matter. But in the meantime, cultivators have access to the USDA's Farm Service Agency's operational and microloans during the crisis, and they always usually qualified for those, depending on as the case may be. So any cultivators who are interested in any of those loans should probably contact an SBA lender and the USDA to work something out, as well as their attorneys, to determine what their eligibility is for those programs. And so with that, I am going to open it up to questions.
So Spencer, I have a question regarding crop insurance. Is crop insurance available in connection with the hemp?
Yes. The USDA actually created a multi-peril crop insurance pilot program earlier this year to cover losses for hemp fiber, grain, or CBD oil. And as you can imagine, the actual coverage hinges on the THC content of the harvest. So if it exceeds the 0.3% threshold that we've been discussing this whole time, there's no coverage. So unfortunately, and that program was available in select states. I believe it was 20 or 21 states that program was available in. But unfortunately, the deadline to apply for that program was March 16th. But if the program is successful and there's high buy-in and subscription amongst cultivators, we'll likely see it extended or expanded in the future. And there's also private underwriters who, depending on what their underwriting requirements are, may write crop insurance policies for hemp. So those are out there.
And then what about for some of our banking clients who might be approached by hemp farmers or hemp businesses? What should those clients be considering as they get into this space?
Well, probably the couple things that they should be aware of, and I'm not going to get into the specifics of these, but some things that they need to keep their eye out for are, Bank Secrecy Act, implications, money laundering implications, to the extent that, you know, a farmer is producing non-compliant product, know your customer requirements as well. To the extent that a farmer or a cultivator is producing non-compliant hemp, remember that if it's non-compliant hemp, it's considered marijuana, which is a federally illegal product, and so the bank runs the risk of the proceeds of their loan being used to facilitate the production of an illegal substance. So that's another thing that I would caution them to consider, as well as just the collateral issue. How are you going to collateralize the loan to those businesses? Because, you know, if you ever had to enforce your remedies against the cultivator, the bank may not be licensed to actually handle the hemp. So if they're not licensed, they need to find somebody else who is licensed to actually take possession of it. And so you might see a lot of, you can probably analogize to the liquor industry for, you know, secured creditor remedies in those situations. But those are the probably three main issues that I would be aware of as a financial services company.
Gotcha. And I think we have one other question from the audience, and this goes back to the slide where you had shown the states and kind of, so states are literally all over the map. How would you advise hemp manufacturing clients in a total THC state that purchases hemp from a Delta 9 THC state? Is that something that we're currently dealing with?
So I take that question to mean a state who has adopted the total potential THC requirement, which is a little more, it's less forgiving for a cultivator, and they're also looking at opening shop in just a Delta 9 state. Is that right? Or maybe the opposite, the other way around. Is that kind of, does that summarize that question?
I think that's right, Spencer.
So they need to, what I would, functionally, they should produce hemp at the lowest or to the most restrictive requirement that they're dealing with. So in that situation, I would try to keep my, if I were the cultivator, I would keep my THC concentration under 0.3% total THC, because you know that's going to also be compliant in the Delta 9 state as well.
Understood.
There was a second. Was there a second part to that question? I may have forgotten.
No, I think you've addressed it. I think you've addressed it.
Okay.
Thank you, Spencer. You did a great job. And for all you folks that are listening, if you have any follow-up questions, please don't hesitate to reach out to either Spencer or myself. We want to thank you for participating in our webinar today. And please don't forget to complete and submit the survey that will display at the conclusion of this webinar. Thank you.
Thanks, everybody.
Bye-bye.